all of you?
Absolutely, sir.
Yes. My esteemed colleague on the Bar Council, Advocate Sangram Desai, all the office bearer, Honorable Umesh Sawanji, and all other office bearers of the local bar association, many senior members who have joined for this webinar, and also my all advocate colleague, young friends from the bar. It's again a great opportunity to interact with all of you. On 25th January 2020, there was a very well organized program at Sindhudurga, and I think it was at Urus, and I got that opportunity to have an interaction. Our very senior friend and guide and philosopher, Advocate Valavalkar, was present in that seminar, and thereafter he has given a message to me that he appreciated that entire program. So it is one of the certificate for me because I have always treated him as one of the really stalwart who should be respected in all corners of the bar. So basically I know that in a Konkan region, many district judges who comes there and who have worked there, they gives an example of a meticulous working on a procedure, whether it is a civil side with a civil procedure code, whether it is a criminal side on a criminal procedure code, even on an evidence act, even on a Mohammedan law, principles of the Mohammedan law, principles of the Hindu law, and it's working. It's very particularly methodical working, which all the judges who have worked with the various bar in the Konkan region, in most of the bar, it has been appreciated, particularly at Ratnagiri, Sindhudurga, Uras. Many district judges who comes across some dialogue, they always appreciate the working. I think we are all there from a local bar, and we can also take a liberty to interact in a Marathi also, if found necessary. कोर्ट कामकाजाची भाषा ही मराठी आहे आणि त्याकरता आपण सगळ्यांनीच भांडलेलो पण आहे, पण प्रयत्न पण करतो आहोत. आणि त्याच्यामुळं पूर्वी असं म्हणायचे की कोकणामध्ये अगदी कडक भांडतात. मला स्वतःला अनुभव नाहीये, पण असं सांगितलं जायचं की ज्याला आपण म्हणतो की नेटानं लढाई, तत्वाची लढाई, आणि ती शेवटपर्यंत, आणि ती कोर्टापुरती मर्यादित, ते झालं की पुन्हा बांधावर येऊन आपण मित्र. या पद्धतीने in this process, the working of this entire region is always appreciated. So when I am supposed to speak on the civil procedure code, I requested Sangramji to go to a particular area because it's a vast subject. We can have some slight bird eye view if we get 2 hours time, which we have done when I think there was a seminar on 25th January at your place. But instead of going into the entire detailed subject of the civil procedure code, I particularly requested Sangramji this time to have a focus on the Bombay High Court amendments to the civil procedure code, because it's my own experience as a lawyer, practicing lawyers, that we don't keenly go through this all state amendments. And if you see, they are very well designed, usefully drafted by the Bombay High Court, and it is applicable. It is on an equal footing. So we should go through that. And therefore, my request to Sangramji was that we should start with this lecture, because he requested to have a dialogue on the Evidence Act. I said that definitely we can go for an Evidence Act in the next lecture whenever you will call or whenever it is comfortable for you. But by that time, before that, let us talk on this state amendments. So he agreed, and I'm thankful to you, Sangramji, for that. Now the question is that, what is CPC? This question, always I open the topic with this question because after practicing 5 years, 10 years, 20 years, or maybe 30 years also, we don't give a thought to this particular aspect, that why it is a code Civil Procedure Code, particularly many types of the enactments, they are designed as a code. Criminal Procedure Code, Indian Penal Code, Civil Procedure Code, Maharashtra Land Revenue Code. Why it is said to be a code and why it is not said to be an act? Because evidence is an act. There are many other acts, but there are few codes. So naturally, the interaction when we are doing academically, the first and foremost question which should arise in the mind of the practicing lawyer, that why code is used and why not act is used. So if you try to find out what is exactly contents of this document of the CPC is there, and if you just go through the index of the Civil Procedure Code, you will find that it contains sections from section 1 to 158 sections are there. Then you will find that in section 121, there is a provision that in addition to this section, there will be schedule 1 of the rules to these sections. These are orders. Schedule 1 is the various orders, order from 1 to order 51, having each the different types of the rules included in that particular order. So this 1 to 51 orders are attached to sections by virtue of Schedule 1. Schedule 1 says that it is a part and parcel of the code, and therefore it is attached to each other by the provision of section 121. That is chapter 10, where the all rules making powers are there. And by that, this is a different document where rules are also included in the one and the same document. Because if you see other documents, act is there. In an act, rule making powers are given. By use of that rule making power, many other rules are made, which are the independent piece of documents. Kindly consider the Maharashtra Regional Town Planning Act. For example, you will get a rule making power in the act, and by using that rule making power, many other rules are made, development control rules. So many rules are there. It becomes an independent document. So rules and acts, we know well. And it is always said that rules are the wheels of the act. Rules are the wheels of the act. And therefore, the provisions of the act are always taken ahead. It is given an effective direction by the proper use of the rules. So rules are very small but very important wheels of that particular act. Unless the rules are there cannot be the advancement of the act, the substantial provisions of the act. The rules play an important role as far as the application, implementation of the substantial provisions of the act is concerned. So orders are rules. So orders are the wheels of the substantial provisions of the Civil Procedure Code. Not only this, if you see the index, there is also Appendix A to H, which is a part of the CPC. It is not an attachment. It is part of the CPC. And therefore, this Appendix A to H has a binding force. For example, if you go for the Appendix A, different drafts of the different plaint or different written statement, they are prescribed there in Appendix A. And they will give you a specific pleadings which are required to be added in the suit or in a written statement. You can't avoid it because it is a part of the code, Civil Procedure Code. As you can't avoid the provisions of the law when you are conducting a civil suit, you can't avoid the Appendix A also, neither other Appendix B, C, D, whatever the judgment, the format of the decree, the summons, and all other formats, they are there in another appendix part, and the design must be, the words must be, the format must be as per that particular formats given in the different appendix. Today I am not taking you to the larger part of that appendix. It is required to be given a consider whenever, but I will just make an appeal to the young friends, practicing friends, that whenever you are making a particular type of suit, kindly refer to that particular format given in appendix A. All suits are formulated there, and see the bare minimum 5, 5, 6 lines prescribed in that particular format, and verify whether your plain includes that minimum lines. Similarly, the case is of the written statement. Similarly, if you are giving a notice to produce, if you are giving a notice for any attachment, or you are giving a notice for an interrogatories, all these formats are there. You have to see the format. You can develop your own, but minimum words which are there, the requirements which are there, that should be there in your application also. Many times it happens that we ignore it, and if it is challenged properly, it goes to the root that it is not in accordance to the civil procedure code, and therefore it is many times in a higher court it is questionable, rejected, or you get some sort of a defeat there. So this is the entire scheme, and therefore it is called as a code. If you see the simple meaning of the code in a Marathi, it is said to be a sangraha. Sangraha, कशाचा संग्रह? Section, orders, appendix. याचा सगळ्यांचा संग्रह तो आहे, आणि तो त्याच्यामुळे एक फक्त सेक्शनचा डॉक्युमेंट नाही, तो या सगळ्यांचा संग्रह आहे, आणि म्हणून त्याला कोड म्हटलेला आहे. So this is code. Whenever the word code is there, you must take a mind as a lawyer that there is not only sections, there is something more which is a part of the document, and it is obligatory. When it becomes a part of the document, it is not a guide, or it is not as an example for some sort of an explanation, but it is a part and parcel. And therefore, friends, one must take into this account, and accordingly we should look towards the provisions of the entire civil procedure code. It is therefore a code. I always look towards civil procedure in this manner. रेल्वेची इंजिन जसं चालतं, रेल्वे जशी चालते, ती ज्या रुळांवरनं चालते, त्या रुळांचं काम दिवाणी दाव्यासाठी दिवाणी संहिता करत असते, सिव्हिल प्रोसिजर कोड करत असते. ही दिशा आहे, हे दोन रेल्वेचे रूल्स आहेत. या रुळावरनं तुमची जी काही दिवाणी दाव्याची गाडी आहे ती चालवायची आहे, आणि म्हणून ती त्या रुळावरच चालली पाहिजे. जशी एखादी गाडी रुळाच्या बाहेर गेली की ते गाडी खाली रुळावरनं घसरते, तिचा अपघात होतो, तिथे विलंब होतो. तसं तुम्ही सिव्हिल प्रोसिजर कोड, दिवाणी दावा असेल तर, क्रिमिनल प्रोसिजर कोड, फौजदारी दावा असेल तर पाळलं नाही की गाडी दाव्याची घसरते, आणि मग त्याला पुन्हा तुम्हाला ट्रॅकला आणायला मेहनत करावी लागते. समोरचा माणूस जर अभ्यास ताकदवान पद्धतीने आपल्यावर अटॅक करू लागला तर कधी कधी दावा नामंजूर होणे, किंवा आपण प्रतिवादी असलो तर आपल्या विरुद्ध दावा मंजूर होणे, अशा प्रकारच्या त्या दाव्यामधले परिणाम आपल्याला भोगावे लागतात. आणि जबाबदारी कोणाची आहे शेवटी हे सगळं करताना? ही वकिलाची जबाबदारी आहे. कारण काय सिव्हिल प्रोसिजर कोड आहे, काय प्रक्रिया आहे, काय प्रोसिजर काय, हे काय त्या लेमॅन असणाऱ्या पक्षकाराला माहित नसतं. आणि म्हणून पक्षकाराची याच्यात काय जबाबदारी नाहीये. जबाबदारी आहे ती त्या फक्त आणि फक्त वकिलाची आहे, आणि म्हणून वकिलाला सनद दिलेली आहे की तो त्या प्रोसिजर प्रमाणे काम चालवेल, पुराव्याचे तत्व समजून घेऊन तो काम चालवेल. तो कुठला तरी कागद खिशातून काढून कुठल्या तरी सिनेमातला हिरो कोर्टामध्ये उंच उडी मारून तो कागद देतो, जसा कागद देणार नाही तो. तर त्याकरता त्याला दस्तावेज यादी लावावी लागेल. त्या दस्तावेज यादीच्या सोबत त्या दस्ताला एक शीट लावावं लागेल. त्या शीटच्या खाली मूळ डॉक्युमेंट लिहावं लागेल. मूळ डॉक्युमेंट नसेल आणि तो झेरॉक्स असेल तर तो का तुम्ही मूळ देताय त्याचं कारण द्यावं लागेल, आणि त्यानंतर तो डॉक्युमेंट कोर्टात जाणार आहे. ही प्रोसेस आहे, ही प्रोसिजर आहे, आणि ही प्रोसिजर काही ठिकाणी मॅन्डेटरी आहे, काही ठिकाणी थोडी फ्लेक्झिबल आहे. सीपीसी बद्दल आपण असं म्हणतो की अल्टिमेटली प्रोसिजर्स आर हँडमेड अँड दे कॅन बी युटिलाइज्ड, accommodated, converted towards the aim if permissible. Not always necessary, because many times if the procedure is mandatory, and if you are not following that mandatory provisions, you will get a setback. And therefore, it is not only the Disha Darshak thing, not only the directive thing, it's a mandatory part of the civil procedure code also. And lawyer, as far as procedure, should observe the procedure. See, if the doctors are there, now we are all living in a corona era, and we heard these words, a protocol given by scribe, a protocol, medicine protocol given by Egypt or Italy or America, etc., etc. What is this protocol? It's also one particular type of a procedure recognized by the authorities in a medicine. So this is not only protocol, it's above protocol. It has some mandate, and therefore it is a fixed procedure. And procedure must be followed because the Constitution recognizes that all rights cannot be denied without the process, legal process of the law. And therefore, friends, we are obligatory, we must follow this procedure for conducting the civil trial. Now coming to our topic, today's topic, real topic, which I want to discuss with you, with some good examples in hand, with some, if you want some interaction on this particular aspect of an amendment, let me talk something about a word amendment. Because we had an impression, we make an amendment in a suit, we make an amendment in a written statement, we make an amendment many times. We use this word amendment many times. The question is that how the word amendment has been seen. So we can go to the High Court amendments. We can see what is the exact nature of Order 617 also. But before that, the word amendment must be appropriately understood by the lawyer. Original something is there, and for giving some correction in that original form, an amendment is to be made. So amendment is a change consequential to the original structure. It may be constitution, it may be suit, it may be some any other document. You can't change the original thing by making of an amendment. This question arises when the debate of constitutional amendment was going on. You'll say that right from CPC, now you are taking me to the constitution, but interesting words of some of the judges I want to quote you, and therefore I'm taking you to the constitution. It was a time where the constitutional amendment after the period of an independence was in a debate between 60 to 70. And there was a case of Golaknath. And then a famous case, which we all know by heart, Keshavananda Bharati, came before the Supreme Court. You know, Supreme Court at that particular moment was constituted with 13 judges to decide what is the scope of Article 368 and to decide what is the scope of amendment of the Constitution. Whether the legislatures are empowered to amend the Constitution. This was a core issue. If they are entitled, to what extent they can make an amendment. And there was split of opinion. 6 judges in this case said that legislatures are the authors of the Constitution. By using the power under Article 368, they can entirely amend the Constitution. They had a full power. There's no restriction at all. 6 judges with exactly opposite view said that no, you don't have any power. You can't make an amendment. You are not a legislature for that. It was a constituent assembly, which was a different form of representatives of the countries. And you are now the parliament. You are not entitled to change the constitution. Not a single word can be changed from the constitution. 6 versus 6 was the fight. 13th judge was an important one. And he was none other less than the great jurist of this country, who has taken the heights of the independence, integrity, straightforwardness of this country to a different height. And he was Justice H.R. Khanna. Justice H.R. Khanna said, friends, it's all right that we are talking about the constitution. It's a great importance. The question is that what we are dealing with. We are dealing with the word amendment. And what is an amendment? What is the literal meaning of an amendment? The rule of an interpretation says that take the literal meaning of a word amendment. So he said that the literal meaning of the word amendment is that to make some consequential changes to give a more correct and elaborate meaning to original subject matter. Amendment does not mean that change the original. And therefore he brought a new theory of a basic structure of the constitution. He said that you can amend the constitution by using the power of Article 368, but without touching to the basic structure of the constitution. So what is the basic structure, etc.? I will not take your time on that particular aspect. You know that aspect, basic structure. Now it's a quite differently developed entire theory of a basic structure of the constitution. But the point which Justice H.R. Khanna said was that this particular aspect of word amendment, its grammatical meaning, is more important. Then we'll come to the constitution. We should look into that particular aspect. And on his 13th opinion, the entire case is stable. Now the law has been set there that you can't change the constitution by judging the basic structure of the constitution. So H.R. Khanna has given this interpretation. This great jurist friend has really given a different thoughts to this country. Even in the case of an Adv Jabalpur, when the question was that whether the fundamental right is a gift given by the legislature or it's an inherent quality of a human being. The 4 judges out of 5 said that it's a gift given by the constitution and they can take it back. Fundamental right, if they are gifted, they can take it back. It was only Justice H.R. Khanna, the 5th judge, while writing a minority judgment in Adv Jabalpur, he said that no, friends, I don't agree. It is not a gift given by the parliament or constitution. It is an inherent quality of the human being which has been all at the most recognized or endorsed by the constitution. So even in an emergency, there cannot be an infringement of the fundamental rights. That was the thought of H.R. Khanna. Friends, you must read that judgment and see now that minority view has again become a law of the country by making a subsequent constitutional amendment after the emergency and also by various verdicts. And I must tell the beauty of the jurisprudence in this country, that majority judgment of an Adv Jabalpur was written by Senior Chandrachud sir, a judge of the Supreme Court, Y.R. Chandrachud, and the minority view which was rejected at the time of the 4 judges under the leadership of Senior Chandrachud sir has been now accepted. The minority view has been accepted by Dr. D.Y. Chandrachud, and now he has endorsed in his judgment that fundamental right is not a gift. It's an inherent quality of the human being, which is only endorsed by the constitution. That is the correct view. So coming to an again point of a subject with this scope of a word amendment, when it was thought that the civil procedure courts delays the matter, speed is not achieved, it requires a rethinking, it requires a reconsideration on the backdrop of the social mindsets of this country, particularly in the state of Maharashtra. Bombay High Court, particularly, has done a great research on this particular point. And under this research, friends, particularly in a era of 1976-77, there are number of High Court amendments added to the Civil Procedure Code, but with a basic concept that the central legislature is Civil Procedure Code enacted by the Parliament. It was an old document. Subsequently, it is amended by the document of 2002 Civil Procedure Code, which now we are dealing with. So prior to that, there was a High Court's amendment. As far as the Maharashtra state amendments are concerned, it's few one. Only you know the 9A famous amendment, which was done again in some period of 77-80, and it was subsequently now deleted from the statute book. But as far as the High Court amendments are concerned, they remains. So first of all, Civil Procedure Code includes now sections, orders, Appendix A to H, and also the High Court amendments are part and parcel of the document of the Civil Procedure Code. Again, it is included in this Sangraha. It is now 4 things which we equated, which is a part and parcel of the Civil Procedure Code. 4th one is the High Court amendments made to the Civil Procedure Code. And friends, these are important. To coming to the point of quoting some of the important aspects of these amendments, I will go to some of the aspects of the actual amendments, and to impress that these are important. We are not keeping that much keen eye on these amendments. We are losing concentration while doing a practice, and therefore this is important, friend. I will come to the first part of the amendment. Example, I'm just quoting you a new example, not sequentially, abruptly, some of the important different parts of the statute I'm putting before the for pointing out that these amendments are very much important. First example I will quote. Suppose a caveat is filed by a person against the opponent, and opponent files a suit against the caveat. You know the consequences. What is the meaning of caveat? Section 148A. It says that in case of a caveat, there cannot be an ad interim injunction in favor of the opponent in the caveat if he comes with that relief, unless and until a notice has been served to the caveat. That's why we file a caveat application. So caveat is there. And suppose a case comes, which is really an urgent case, and if you want to claim an ad interim injunction before the court, then in that particular circumstances, friends, what is the remedy? That is my first question, which is my answer. The answer will be your, again, related to today's topic. Many times when we interact in the actual physical classrooms, the advocate comes with some of the logical answers. Yes, we have 151. We can make the prayer to the court. But the court will say that mandatory provision is there. Then what is to be done? The answer is that there is a High Court amendment to Order 40, that is Order 40A to the Civil Procedure Code, in which the Bombay High Court has prescribed a caveat rules. Kindly see that CPC book, which is having inclusion of the caveat, inclusion of the Bombay High Court amendments. Because nowadays, Somebody from a Delhi, somebody from Allahabad sends a book with a prescribed printed material used by so many times, and many times they loses these types of provisions. So first of all, my experience which I have shared can be shared to you, that try to purchase a book on the procedure, CPC, CRPC and all other laws, which is through the publication of the Maharashtra publication. There you will get all these things. If you can go for this book printed in a government publication, see friends, it's a bare act of the Civil Procedure Code printed in a government publication. Of course, if it is available with a very mere cost of 195 rupees, the big book of near about 450 pages, the bare act is available. It includes all these types of an amendment. So under Order 40 Rule A, there is an amendment of a Bombay High Court incorporated on 1/2/1977, whereby you can get a caveat rules as a Bombay High Court amendment. In these rules, you will find that there is rule number 7. In this rule number 7, if it appears to the court that a grant of an interim injunction relief is necessary for not causing a delay in a justice, then by recording the reasons for his opinion, he can grant an interim relief on application of applicant till further orders, even in case of a caveat, and of course by giving a caveator an opportunity of a heard in the next date. So till next date, in spite of a caveat, an interim injunction can be taken if you know that Bombay High Court caveat rules are there. In this rule number 7 is there. By using this particular provision, you can put your case. That will be your rightful, legitimate, legal argument. And not only an argument of 151. 151 is said to be, or used to said to be, a provision which is used. पत्त्यामध्ये आपण जसं जोकर असतो, कुठे काय मिळालं नाही की 151 आहे ना साहेब. So that doesn't impress the court as per my own experience. But if you quote this provision, make an application that caveat is there, but in spite of caveat, urgency is there. If you are not following, if you are not giving an ad interim injunction, Honorable Court, then there will be a completely injustice. These are the points of an injustice, and therefore grant me an ad interim injunction till next date, and then give a hearing to the caveator. Then it is permissible under Rule 7, friends. So in spite of caveat, you can take an ad interim injunction if you know this type of a provision. Equally, there is another document, but it is not a part and parcel of the CPC, but it is called as a civil manual. You know that. It is a detailed procedure which deals with various types of the aspects of the trial at various stages. There also you will find that para number, if I am not wrong, para number 26, 27, somewhere a direction is there to the Honorable Court, because a manual is said to be mainly made for the ministerial work. Does not mean that lawyer can't rely on that provision. It is to be observed. It is again a sort of a rule, a manual prepared for the purpose of conducting a civil trial. And for that purpose, you can go there, and there you will find that para number 26, 27 also supports this particular rule, where it has been prescribed that in case of an caveat, if there is an urgency, reasons to be recorded, and the ad interim injunction can be granted by the judge in an appropriate case. So if you know all these provisions, friends, it is always better that make an application with Order 40A, Rule 7, grant me ad interim injunction in spite of a caveat. The court will record the reason and pass an order. So this is something which we don't use, friends, or many times we are forgotten, many times we have not read these provisions because somewhere in a corner it is recorded as a High Court amendment. Many books does not contain that High Court amendments also. You go on reading the volumes after volumes, big commentary, but the place of this High Court amendment is depending upon the publisher's wish many times. And therefore, we should take care and we should always try to see that these High Court amendments are used. Another important point which I want to High Court provision of a High Court amendment. Small things High Court has given a consideration. Order 7 deals with a plaint, you know that. And if plaint is for an encroachment suit, what is important? Property is important. Description of the property is an important aspect. Here the question is that whether the sketch of an encroached portion is mandatory, and if mandatory, under which provision? You have to go to Order 7 only, because Order 7 gives you a detailed procedure for preparation of the plaint. So the question is that which provision we can use for making such suit of an encroachment where sketch is to be attached. The plaintiff has filed a suit. He has not made a sketch as a part of the plaint. What is the remedy to the defendant? Here I want to point out to you that kindly go to the Order 7, Rule 3. And in this Rule 3, friends, you will find that the encroachment suit must be attached to the plaint by specifying the boundary numbers, and in case of an encroachment, a sketch showing approximately as possible as may the location and extent of encroachment shall also be filed along with the plaint. It is a mandatory thing. Suit can be written back, suit can be rejected if this mandate as required in an encroachment suit is not followed, because you can see the words, it's mandatory. The encroachment suit is there, you are given a description, you must give a boundaries, you must give a description of original property, you must give an independent description of an encroached portion of the property, along with a sketch attached to the plaint showing that this is the original property and this much portion which is described in para number 1 to whatever may be as an encroachment. This is marked in these red lines as an encroached portion. This is a correct pleading. This is the correct part of making of the plaint. And for that purpose, friends, you must follow the procedure. So Order 7, again, Rule 3 is a Bombay High Court amendment. It is not in a central provision, and therefore you have to see that provisions also. Limitation, again, if the suit is delayed, you have to prescribe the limitation. You see the Order 6 of Order 7, Rule 6, you will find that Bombay High Court amendment is there, and with that provision of Bombay High Court amendment, you can make an effective pleading for coming out of the trouble of limitation by giving a proper explanation of a delay, and that proviso is there in Rule 6. You can go to the Rule 7 and you will find that if plaint is not accordingly designed as per this all rules of Order 7 given from Rule 1 to Rule 9, then there can be return of the plaint. Can be rejection also, it can be return also, friends. So this particular aspect is important, friends. And therefore, My personal opinion is that, particularly in a lockdown period, those who are in practice of civil suits, they should make themselves aware with the bare act of the Civil Procedure Code. While doing so, they should make a red line marks on the High Court amendments independently and make a chart, such as I was pointing out some of the provisions. There are many. I can't point out all the provisions, but some of the important provisions I will tell you more, so as to give an importance of these High Court amendments. So original provision Order 7 Rule 3, what is there? The Bombay High Court amendment, what is there? Original Order 7 Rule 6, High Court amendment, what is there? Accordingly, in each provision, you can make out your own text, you can make out your own chart, and just give a thought to that, whether we are really using this. These are effective. These are made, these High Court amendments are made with a particular purpose of giving a speed to the justice, speed to the civil trial, to reach up to the ultimate aim of adjudication of the facts on a truth, and for that purpose giving many instruments in the hands of the litigants so as to use it properly, logically, and to come to a logical end in that particular matter. So for that purpose, the best time is of this lockdown period. So I was referring to Order 7. Now, I will again take you to a very repeatedly required a provision of law, and that is Order 39. Suppose under Order 39, you got an injunction. And in this injunction, friends, the opposite party is making breach of an injunction. So you got an injunction as the plaintiff and defendant is making a breach of that injunction. What is the remedy? First reaction amongst the advocate is that we'll file a contempt. He has caused a breach of an injunction of the court. It's a contempt of the court. Correct? It is a contempt of the court. We must do that. Contempt of the court is a remedy. But for what purpose you are there in a court? Because of the contempt, basically you must be aware, friends, that contempt is to be filed as an independent proceeding. It cannot be filed as one of the interlocutory application in a same suit. You know that famous judgment of Honorable Justice M. Khanwilkar in the Bombay High Court, where this question was aroused and it was decided that it is a completely independent inquiry where an independent civil miscellaneous application is to be filed, and there the inquiry of a conduct will come completed. What is the end of the contempt? The contempt doer will be punished. He has caused contempt, either with a penalty, either with the punishment, conviction, some sort of the contemptuous action will be taken against him. What is your purpose? When you are coming as a plaintiff in a suit, what is the purpose of the suit? The purpose of the suit is to obtain the decree. If you are a defendant, the purpose of a defendant is to reject the suit, obtain that decree of rejection. Therefore, ultimately, the purpose must be understood by the lawyer and will not wait. I will not say that don't go for a contempt. That can be an additional thing. If you have a time, your client has desire for that. Of course, he is paying for you that. That is your independent remedy. As far as the suit is concerned, the remedy should be as per Order 39, Rule 11. Rule 11 is not incorporated in the Central Act. Rule 11 is the Bombay High Court amendment to Order 39. And Rule 11 gives you power or gives you a procedure, if you are a plaintiff, to struck down the defense of the defendant because he has caused contempt. And just you have to show that a contempt is caused, and court has no other option than to struck down his defense. If a contempt is caused by the plaintiff, and if it is pointed out to court by the defendant, the remedy is that the suit will be dismissed. No other remedy. You have to just point out that, see, this contempt. and the ultimate result will be that the suit will be dismissed. This is Order 39, Rule 11, friends. Order 39, Rule 11 is the Bombay High Court amendment in addition after Order 39, Rule 10. Up to 10, you can find that it is a central act, central CPC. After 10, Rule 10, Rule 11 is an amendment made in the by the Bombay High Court notification, and it is available to the litigation in Maharashtra. So again, Order 39, Rule 11 is a different type of a High Court amendment to the Civil Procedure Code. I will take to another angle, and I will take you to Order 8. Order 8, you know that after the defendant appears in a suit, he has to file a written statement. So Order 8 deals with written statement along with a counterclaim. And if you see the Order 10 or Order 8, from Rule 1 onwards, there is a central act up to Rule 10. And from Rule 11 onwards, Order 8, Rule 11 onwards, up to Rule 35, 11 to 35, okay, near about 23, 24, whatever may be, the rules are there. They are state amendments. They are not there in the Central Act, friends. What is that? It's a simple question, logical question I will ask. You know that when the defendant appears and he files a written statement, there is also a remedy available under Rule 6A of Order 8 that he can file a counterclaim against the plaintiff. So defendant can file a counterclaim against the plaintiff. We know that. It does not require any lecture or discussion. The question is different. If there are A is the plaintiff, B, C, D are the defendant. The question is that D do not want to file a counterclaim against the plaintiff A, but he wants to file a counterclaim against co-defendant B or C, whatever may be. So, an intention of a defendant is to file a counterclaim amongst co-defendant. Whether it's permissible, we'll have to find out the solution. And you can go to that Order 8, right from Rule 11 onwards, you will find that the attempt has been made by the Bombay High Court that we will try to incorporate all other disputes related to the subject matter of the suit in one and the same suit. For that purpose, not only a dispute between plaintiff and defendant is to be permitted, but if that particular dispute or that particular subject is related to some third party who is not plaintiff or defendant, then there is a third party procedure prescribed under these particular provisions. And you can go through after Rule 22, there is Rule 23 onwards, 23 to 35. It talks about third party procedure. What is that? If A files suit against B, C, D, and D wants to claim that another E is also interested in this particular property. For example, A files a suit for the partition against their own brother B, C, D. And D want to say that this A has already sold property to E. That is also an ancestor property. This sale deed is done, the money are taken by A, he has suppressed this material. Honorable Court should also call him as a party. That is the contention in a written statement. The question is that you can go for another application for addition of the third party.
So that application will be heard, the order will be passed, that order will be challenged, an independent parallel procedure you will conduct. That is permissible, because making a party is a choice of the court, and ultimately court will see who's interested. To all that particular parties, court can make them a party. That is all right. It's a general provision. Here, without making that effort, defendant has only point out to the court that, see, this A has sold his property to E. He is required there, sir. What is the procedure? The court will issue direct notice to E. His say will be called. Are you really a purchaser of the property? Whatever his say will be there, it will be considered, and court will add him directly either as a plaintiff or as a defendant, considering his stand, whether he is favoring to the plaintiff or defendant. Accordingly, he will be a party to the suit directly, along with the contention against that third party, also against the contention in that party regarding to that party also. His say will be taken and he will be added in the proceeding. So this is called as a third procedure. So notice is there to that third procedure directly. You can use this provision. Why we should go for the addition of the party, then that order subjected to the another thing? The direct provision to that particular aspects are there from order 23 onwards. So similarly, you can see that in these provisions also, the same right to that third parties are available as of a defendant or as a party to the suit. He can appear, he can file his written statement, he can contest the matter, he can participate into the evidence, make the cross-examinations of the witness, he can go for his own evidence, he can bring his witnesses, etc., etc. As if a normal party, he will also get all right. So in this context, Rule 35 prescribes that if, therefore, particular defendant wants to make a counterclaim against a co-defendant, then in the same manner, a procedure which is there under Order 23, he has to serve that counterclaim upon the other co-defendant. And on service, the co-defendant will give a written statement to that particular claim of counterclaim. And then it will be treated as a pleading of the parties, where adjudication on the issues involved in that particular pleading will be done. So Order 8, I was talking right from Rule 11 onwards to Order 35. Kindly verify whether we have gone through these provisions, whether we have taken attention of this provision, whether we have used these particular provisions, how useful they are, because they are applicable to this land. This is a Bombay High Court amendments. By considering the present litigations in the state of the Maharashtra, these particular amendments are done, friends. And therefore, these amendments are important. So now, I will come to one or two amendments, and then we can have some discussion on this particular aspect. Order 21. Order 21, I am talking about a case where decree is there in favor of a decree holder. He has gone for an execution of that decree. And in this decree, it is found that the possession of the suit property is not with that defendant. It is with JD, we call it a judgment actor. It is with some third party. And that third party comes before the court. You know, Order 21, Rule 97, 202. These are all the procedure where third party can come to the court. He can make an application of an intervention. The court can allow that intervention. Independent adjudication will be done. And upon then the stake of execution of the decree will be decided. Here, the defendant has executed the document, the transaction with that third party during the pendency of the suit. So naturally, the decree holder takes a stand that, sir, he is affected by the principle of least pendens. So kindly see Order 21, and in Order 21 there is a rule 102 which says that if this transaction is affected by the principle of least pendens, then that particular person who is doing a transaction during the least pendens do not have a right to prefer an application under rules 98 and 100. I'll read that 102. Nothing in rule 98 and 100 shall apply to the resistance or obstruction in execution of a decree for the possession of an immovable property by a person to whom the judgment debtor has transferred the property after the institution of the suit in which decree was passed, or to the disposition of any such person. In this rule, transfer includes transfer by operation of the law. The question is that what is the position in the state of Maharashtra? What Bombay High Court says about that? Rule 102, which is a central act, says that these particular provisions of intervening into the execution proceeding as an intervener, possessor, title holder is not applicable by using the provisions of Rule 98 to 100 to the person to whom the JD, the judgment debtor, has transferred the property after the filing of the suit. That is, it is affected by the principle of least pendens. When the property is transferred during the pendency of the suit, pendency of any litigation, it is affected by the principle of least pendens as per the provisions, section 52, if I'm not wrong, of a Transfer of Property Act. Here, you will find an interesting amendment. And if you go to Rule 102, you will find that by a Bombay High Court amendment, 102 rule is deleted for the state of Maharashtra from 1 February 1977. I must share you my own experience after writing the 3-4 books on the Civil Procedure Code, CPC approach and trial, and so many books. When I was arguing in one matter, I was damn sure that the lease pendens transaction are not protected under Order 21. And I referred this 102 because it's a very small amendment to this Rule 102. If you see this, you can carefully go through that. It's a very small amendment, deleted word use is there. So I have not gone through it. Just some 5, 7, 8 years back. So one of the junior lawyer come and he said that rightly what Jaibhave sir is selling, that the lease pendens 98 to 100 is not applicable when lease pendens is there. Right, sir, 102 is there. As far as we are concerned, in the state of Maharashtra, there is a Bombay High Court amendment. Because of that, this rule is deleted. And he pointed out, see, this is deleted. And I was surprised. So effect is that Rule 102 is not there. The effect is that a person affected by the lease pendens can make an application under 98 to 100 to obstruct the decree when even his transaction was during the pendency of the suit by using the provisions. And for that purpose, he must see that the small word deleted is there to Rule 102. So in a state of Maharashtra and Goa, this particular amendment does not exist because Bombay High Court has deleted this particular provision. So friends, one last example, and then I will make a comment on the present legal position of this Bombay High Court amendments. Order 6, Rule 17. You know, it's a very famous provision in a civil trial. We use it in a many manner, skillfully. We use it for amending. We use it for adjournment also. We use it for many other purposes. So it's our dear provision, Order 6, Rule 17. amendment of the pleading. The question is that if a situation occurs that in a suit, defendant is ex parte, in spite of service of the summons, he has not appeared, not file a written statement, or even file a written statement thereafter, he is not present before the court, whatever may be the circumstances. And in such suit, if plaintiff wants to amend the suit, so in this particular circumstances, whether a fresh notice should be given to the defendant who is ex parte, or it is not required. He can straightway go to the amendment application and pray the court that kindly allow this amendment. This is necessary. This is fulfilling the all criteria. You can see the provision of Order 6, Rule 17, Central Act. There is no such embargo. There is no such provision which will compel the plaintiff to go for a fresh summons to the defendant. But if you go to Order 17 or Order 6, Rule 17, which is a Bombay High Court amendment of Rule 17, a completely new substituted Rule 17 of a Bombay High Court to Order 6, that will say that if these circumstances occur, of course with the leave of the court, the plaintiff has to forgive a fresh summons to defendant. So now there is a difference. Central Act say does not make any such type of a provision, but a state amendment makes a provision that in an ex parte suit, plaintiff wants to make an amendment, he should give a fresh summons to defendant. Now, this particular aspect has to be looked into the light of Section 16 of the CPC Amending Act of 2002. You can see this Civil Procedure Codes Bare Act. You will find that right from this particular statute is enacted in 1908. Since 1912, 14, 23, 40, 27, so many amending acts are passed. Amending act are having a same nature as of application of an amendment. You make an application of an amendment in a suit, your amendment is allowed, that amendment is carried, it has gone into the main part of the suit, the purpose of amending application is fulfilled. So what is the effect of that now amending application in that particular suit? Practically it is purpose is fulfilled. Now the purpose is infructuous. It is of no use. Similarly, when particular act is to be amended, an amending act, an independent statute, an independent instrument of an amendment is proposed to the Parliament, if it is Central Act, to the Assembly, if it is State Act, it is passed there, it is approved, it is notified, and from that particular date of the notification, the amended part goes into the main statute and the purpose of amending act is over. So it does not take now effect. But this is important when the question of interpretation comes, particularly on the point of repeal and saving done by this amending act. So when the Civil Procedure Code was amended substantially in year 2002, this amending act of CPC 2002 was passed by the Parliament and it was effected. Accordingly, the amendment was brought and they are carried forward in this particular document of CPC. But it remains an independent document, and in that document, there is one section 16. In that section 16, friends, there is a provision. Interesting. It says that henceforth, means after the amendment of 2002, effective date of amendment of 2002, the state amendment or the High Court amendments which are inconsistent to the main statute of the Civil Procedure Code stands repealed. After the amending Act of 2002, the state amendments or the High Court amendments which are inconsistent to the Central Act of CPC stand repealed. What is repeal? A simple line has been explained by Sir Dr. A.C. Awad. He says that repeal means not born, means not, it doesn't have any effect, or it was effective prior to this date, previous to that particular era, for that particular transaction it will be effective, but after this date it will not be effective. This is not an interpretation. The interpretation of word is that it doesn't exist at any time. It was not born at all. The provision was not born at all. That is the context of the word repeal. And saving is means some part is saved for this particular period. So it can make an exception to repeal. So the repeal means it is not in existence. It was not in existence. So the High Court amendments and the state amendments which are inconsistent to the Central Act, they stand repeal. This is the provision, friends. So the effect is that this Order 6, Rule 17 was challenged before the Bombay High Court, stating that the Bombay High Court amendment, Rule 17, is inconsistent to Rule 17 of the Central Act. Because here, in a Central Act, it is not prescribed that in an ex parte suit, if the plaintiff wants to make an amendment in a suit, a fresh notice should be given. This provision is not there. Whereas, a inconsistent provision has been made in Rule 17. What is meant by inconsistent? Against the spirit. Against the spirit of that particular. Does not mean that one word, two words are here and there. In totality, the spirit of two provisions are against each other. And the spirit of the High Court amendment Bombay High Court and Justice Vasibdar sir has delivered a judgment in 2011, which is reported in MLJ. You can see that judgment. In that judgment, it has been stated that the Order 6, Rule 17, Bombay High Court does not exist because it is inconsistent to the original Rule 17 and therefore it stands repeal. So friends, when we are talking about the High Court amendments, one thing is that we must give a proper attention to that amendments, their spirit, what is the purpose behind that, one part. Second part, we must also verify whether these particular provisions are against the spirit of the Central Act. And for that purpose, whenever the High Court amendments are going to be used, this can be a possible argument that this provision is against the spirit of the new amended 2002 Act or even the old Act. Though it is Bombay High Court amendment. So naturally, this is the simple rule of an interpretation. The Central Act always have an overriding effect over the State Act. And these are not mainly the State Act as such. It's not out of the legislative powers of the state also. It is out of the rule-making power of the High Court. The High Court and the Supreme Court, they are not the legislators. They are not supposed to interfere into the legislation, but they can always make the machinery of the High Courts and the other subordinate courts to run into a proper spirit. For that purpose, whatever the policy, decisions, resolutions, rules, they are to be made, that can be always made by the High Courts. So the only condition is that for that purpose, they have to see the spirit of the basic law, and without going against that spirit of the law, they can always make it. So accordingly, I have quoted you 6-7 amendments, friends. There are many others, and they are useful. You can see various other provisions. Try to find out all these provisions yourself. I have just shown you one of my vision that this can be an important area, the High Court amendments. And these High Court amendments are forgotten. As far as I'm concerned, I can frankly tell you that I have forgotten that. Till I started academically working on the Civil Procedure Code, I have not given a keen attention to this. But the day I got it, and when I argue on the suit to obtain an ad interim injunction in spite of caveat, and I got it, that was a great day of satisfaction in my life. That's something by using the real spirit of the law. I have argued and I got some relief for my really needy client. So this is good for all the lawyers, whether he's a senior, whether he's a junior. Senior lawyer can share you in such a circumstances, but in spite of caveat, when you can give him an ad interim injunction, he is a client of the life, friends. He will never forget you. He will tell others that yes, my lawyer is such a lawyer that in spite of the caveat, without issuing notice, he got an ad interim injunction. He will not know what is the provision, what are the High Court amendments, and what is the difference between the High Court amendments. He only knows this, that my lawyer got that ad interim injunction. And you got it because your case was strong and because you did not only pray for sympathy to the court, but you have shown the substantial provision of the law to the court and claimed a relief on the basis of that particular provision. So that is important. When you start working this really by using the right procedure, friends, it is a time when the lawyer is said to use his skills. That is a skillful advocacy. And the purpose of all this discussion is that by making a contribution to each other's, we should always try to make a skillful advocacy. It should not be random. It should be well-designed act, like an architect. What I have to do as a plaintiff, what I have to do as a defendant, which provisions I am going to use, which law I am going to use, which authorities are supporting to me. All this research should be made. And for that purpose, when you are using a CPC, just my own experience, which I share, that always try to find out some substantial provisions which is there in section or order or in a High Court amendments. Put that in your all applications. Whenever you are putting any application, you are putting an amendment application, put there Order 6, Rule 17. You are making an adjournment application, put there whatever order, this, I think 16, 17 order is there, whatever may be, try to put that particular order there. Your work will be appreciated by the court. The court will be well impressed with you, and the provisions which may be wrong will be corrected by the court. Court will tell you that try to correct this, or some senior will tell you that try to correct it. It is not 17, but it is 18, or it is not 18, it is something 12. It's all right, doesn't mix. You have tried your best, and that particular practice will make you perfect for traveling on these rules of the CPC. This is the smooth travel, friends. When your rules are smooth, where your engine is smooth, your train is smooth, and your substantial goods, of course, must be strong enough to get you result. And therefore, friends, by making a combination of all these things, it's my humble request to all of you that try to find out the correct path. So as far as the CP is concerned, the lockdown, as per my opinion, is the best period to make this exercise. First, go through the Bare Act entirely, the sections, orders, and the High Court amendments. Secondly, try to mark the different High Court amendments to each and every sections and orders. In sections, it is not there, only in a 9A is there, but in orders, many places you will find that these High Court amendments are there. Thirdly, I will say that try to compare the CPC with the civil manual. If you are going to use an instrument of appointment of the commissioner, you will get some provision in a section, some provision in order, and an elaborate procedure in a civil manual. That is useful for you for making an application, for conducting the work of the commissioner, for making a cross-examination of the commissioner. So this comparative chart should be prepared by you yourself, and that will be useful. So such a free time is not available at any moment. This is the only time where we can do all this exercise. Though the corona has caused a lot of effects to the lawyer community, I know that. Lot of the youngsters, lot of the other persons dependent on the profession, they are worried, they are in trouble, they are in a need. We know that as a bar council, we all are trying to help them. We are doing our best. But apart from that, the best asset of the profession is the perfect knowledge. And knowledge means what? We don't have to remember all the provisions. We have to find out our paths. We must know, if I want to go for an interim injunction, what should be my remedy for contempt? It is somewhere in Order 39, and somewhere there is some sort of a High Court amendment of Rule 11. This will be sufficient for you. Then you can go to that provision of Rule 11, see that Rule 11, read it, and draft your application. But in your mind, somewhere, it should be clear that this provision is there. So for that purpose, you can prepare your own charts. I have always shared some charts to my dear friends in some of the lectures. I will send it to Honorable Member Sangram Desai-ji to distribute amongst you also, so as just to share my own experience of preparing the charts. But I will make an appeal that don't use that chart. Prepare your own charts. Just take the vision from that particular chart, how the charts are to be prepared, how the comparison is to be prepared. There is a natural sequence in an entire civil procedure code, friends. Just like a natural principle of justice, nothing more. A logical common sense, a human common sense of a natural principle of justice is to be observed. That all sequence we will follow, you will observe that that is there in all sections, orders, and all provisions of the civil procedure code. So it's your pleasure. I'll just request the Sangramji that if any questions are there in 10 minutes, we can complete, because some other commitment I have given to one of the Bar Council member. And for that purpose, I'm thankful, Sangramji, for having a good sharing. It's always pleasure for me to come in any area of Sindhudurga, Ratnagiri, anywhere, whenever you are called. I'm always there, as I'm a lover of Konkan, and I'm thankful to giving this opportunity of interacting with all of you. If you have some questions in this 10-minute time, I will definitely try to answer as per my ability. Thank you very much.
Thank you, Jaibhave sir. There are a lot of questions, but as there is a time constraint, it seems that we have to go at 5. So I had requested the members to, as far as possible, cut short their questions. So there are a few of them. I would request them kindly. Amulji, you have a question, please ask the question. Yes, Amul, please go ahead.
Sir. Good evening, sir. Sir, as the rule 102 is deleted, so what is the remedy for that purchaser?
No, that subsequent purchaser can file a intervenor application under Order 21, Rule 98.
Yes, sir. Thank you.
He can file that application. He is not prohibited by Rule 102 because it is deleted.
Yes, sir. Thank you.
Okay. Anybody else who wants to ask a question? Please go ahead.
Hello.
Yes.
Hello.
Yes, go ahead.
Sir, are you audible? Hello.
Yes,
Hello?
you can ask. You are audible.
Yes,
Please ask.
sir. I have query की CPC ऑर्डर 9/13 खाली सेटिंग असाइड एक्सपायर डिक्रीची तरतूद आहे आणि त्याचबरोबर ऑर्डर 41 खाली अपिलाची पण तरतूद आहे. तर त्यामध्ये एखाद्या समजा मोर दॅन 2 डिपेंडंट असतील तर एका फर्स्ट डिपेंडंटनं 9/13 खाली ऍप्लिकेशन केला सेटिंग असाइडला आणि दुसऱ्या सेकंड डिपेंडंटनं समजा अपील केलं तर विच विल प्रोसिडिंग विल सर्व्हाइव्ह.
हॅलो, हा जरा आवाज नीट नाही आला, पुन्हा बोला.
सर, CPC ऑर्डर 9-13 खाली सेटिंग असाइड एक्सपायरी डिक्रीची जी तरतूद आहे, त्याचबरोबर ऑर्डर 41 खाली रेग्युलर अपिलासाठीची जी तरतूद आहे, तर त्यामध्ये मला असं म्हणायचं आहे की 2 पेक्षा जास्त प्रतिवादी एखाद्या प्रोसिडिंग मध्ये आहेत, दाव्यामध्ये आहेत, तर त्यातला फर्स्ट डिपेंडंट आहे तो ऍप्लिकेशन 9-13 खाली त्याने मूव्ह केला आणि दुसऱ्या सेकंड डिपेंडंटने समजा अपील केलं ऑर्डर 41 खाली, तर त्यावेळेस विच प्रोसिडिंग विल सर्व्हाइव्ह?
माझ्या मते 9-13 खालचं सर्व्हाइव्ह होईल, कारण डायरेक्ट रेमेडी इज देअर, बट आय एम नॉट शुअर. म्हणजे मी बघेल आणि तुम्हाला पाहिजे तर व्हॉट्सअप करून टाकेल.
ओके सर, पण मला त्याच्या पुढे दुसरी अशी अजून त्याच्यामध्ये क्युरी आहे की अपार्ट फ्रॉम दी सर्व्हायवलनेस ऑफ द प्रोसिडिंग, परंतु जर समजा त्याच्यामध्ये पुढे अपील कोर्टाने डिग्री कन्फर्म केली, एक टीजी आणि एक्सपायर डिग्री, पण ट्रायल कोर्टानं 9-13 खाली ऍप्लिकेशन आहे तो अलाउड केला आणि सेटिंग असाइड एक्सपायर डिग्री म्हणजे सेट असाइड केली, तर मग व्हॉट विल बी द कॉन्सिक्वेन्सेस फर्दर ऑल्सो? म्हणजे त्याच्यामुळे पण
ते कॉन्ट्राडिक्टरी होईल. मला असं वाटतं की ते कॉज एकच असल्यामुळे विल हॅव टू क्लब दॅट ऍट वन प्लेस, अदरवाइज इट विल क्रिएट अ कॉम्प्लिकेशन. फॉर दॅट विल हॅव टू सी द रेमेडी. आता लगेच 2 मिनिटात सांगता नाही येणार.
नाही, ठीक आहे सर, आपण पुढे परत आपली भेटगाठ होईल त्यावेळेस मग मला
जरूर बघूया.
ओके सर, थँक्यू सर.
थँक्यू व्हेरी मच.
Yes, anybody else having query, please go ahead. Sir, I think there is one query about section 9A.
हो, विचारा ना.
Clarity about section 9A. Yes, please go ahead.
9A, see, I will just tell in general, the 9A is now deleted, or it is repealed. Not to use the word delete, it is actually the repeal now by the state amendment. The effect is that there can be 2 consequences after that repeal. Now there are 2, एकामागे एक 2 अमेंडमेंट केल्या त्यांनी. त्याचं कारण असं होतं की एक कशी सर्कमस्टन्सेस आहेत की समजा एखाद्या याच्यामध्ये ज्युरिस्डिक्शन नाही असा घेतलाय आणि सूट रिजेक्ट केला आणि अपिलात गेलेला आहे, आणि एकामध्ये ज्युरिस्डिक्शन आहे असं धरलेलं आहे. तर ज्याच्यामध्ये ज्युरिस्डिक्शन नाही असं धरून वर अपील गेलेलं आहे, त्या अपिलाबद्दल दुसरी त्यांनी अमेंडमेंट केली, आणि दॅट अपील विल सर्व्हाइव्ह. ज्युरिस्डिक्शन आहे या संबंधामधल्या ऑर्डरचं काय अपील असेल तर ते सर्व्हाइव्ह राहणार नाही. म्हणजे काय की ज्युरिस्डिक्शन नाही, दिस इज अ डिक्री. यू कॅन टेक द डिफिनेशन ऑफ द वर्ड डिक्री. व्हेन द प्लेंट इज रिजेक्टेड ऑन द पॉइंट ऑफ द ज्युरिस्डिक्शन, it is included in the definition of decree. So it has gone into decree. Jurisdiction आहे ही ऑर्डर डिक्री नाहीये, आणि तिच्यामुळं जी डिक्री आहे त्या डिक्रीवरचा अपील मेंटेनेबल केलेले as far as the even after the repeal of 9A by second amendment. So that appeal will survive. That particular appeal will be heard on merit, and accordingly the decision will be given. But if some revision is filed अगेन्स्ट द ज्युरिस्डिक्शन, येस, अफर्मेटिव्ह ज्युरिस्डिक्शन आहे, तर ते मात्र सर्व्हाइव्ह होणार नाही, कारण ज्युरिस्डिक्शन आहे तिकडे सूट चालेल. त्याच्याबद्दलचं त्यांनी पुढची रेमेडी कॅन्सल करून टाकलेली आहे. ही आजची माझ्या माहितीप्रमाणे असणारी लेटेस्ट पोझिशन त्याची आहे.
ओके सर, क्वेश्चन तर खूपच मेसेजेस येत आहेत मला, पण आय थिंक मी जर विचार लागलो तर ते तुम्हाला 5 वाजता दुसरं लेक्चर आहे, सोडू आहे आज.
तुम्ही 5 वाजता मला ते व्हॉट्सअप करा, मी ते सगळ्यांची मला जेवढे पॉसिबल तेवढे उत्तर पाठवून देईल तुम्हाला.
येस डेफिनेटली
माझ्या पर्सनल व्हॉट्सअपवर पाठवून द्या. आय विल डेफिनेटली ट्राय टू रिप्लाय मॅक्झिमम क्वेश्चन्स.
Okay. Sir, thank you very much, sir. This was the 6th webinar held by the Sindhudurg District Bar Association with Ratnagiri, Goa and lawyers from Kolhapur. So initially, sir, we started with just 50-60 lawyers, but today we were above 160 lawyers for this particular today's webinar. So we are growing as, we are proceeding in a very right way. On 15, Justice Abhay Tipse has agreed to come and give us a lecture also. So we are always, requesting different senior lawyers to come. Anyway, sir, I thank you very much because you have been a great inspiration to all the juniors and for me also in Bar Council of Maharashtra and Goa. I thank you very much for sparing your valuable time and coming and giving us this lecture. Thank you very much, sir. And we'll again meet for the lecture on Indian Evidence Act. Thank you, sir.
Definitely. Thank you very much.
Thank you.
लिव्हिंग कर ना मीटिंग.